Hello there. Somebody's been asking me whether or not they should run a preliminary exam. This is something that defense attorneys get asked a lot, and our general answer is no. The prosecution only has to prove probable cause. Was there a crime? Did you commit it? Or probably so. You can be as innocent as all get up, and the judge can still quote unquote bind it over. That does not mean you're guilty or ever will be convicted. It just means enough evidence to move it to circuit court. Um, Even if a victim admits they've lied, or made prior inconsistent statements, even if you might have a claim of self-defense, even if the victim's not that credible or some of the witnesses aren't, the judge will still often bind it over. The only times we ever really win on these is if you have like an assault case and the victim gets up there and doesn't allege an element of the offense. For example, if you're charged with assault with strangulation and the victim testifies and says, this person hit me, punched me, but they never mentioned strangulation, you might get that charge either reduced or thrown out. They could just recharge with some other kind of lesser assault. I had a case a few months ago in West Michigan here where a guy was charged with attempted murder for trying to, I guess, they're thinking he was trying to kill his I guess, girlfriend with a baseball bat. And at the prelim, she said, no, I don't think he was trying to kill me. So that charge went away. The guy was still had other charges that didn't beat the whole case. But by and large, we recommend waiving it because it just often isn't going to win for you. I know there's sort of this mythology in some segments of society that you should always run your prelim and this and that, and that's fine. But more often than not, you're wasting your time. And the other thing you risk is you could have witnesses against you getting a dry run at their testimony. So if you get somebody that's going to maybe come off bad in front of a jury, if you run the prelim, they get a free shot to testify, and then they get, 6 months, a year before trial to kind of rehearse and clean themselves up and overcome some weaknesses. You don't necessarily want to do that either. So generally, we advise you to waive it. There's really good reasons for it. Once in a blue moon, we want to run it to preserve testimony, or we just know an element of an offense just isn't there. And when the prosecutor insists on running it, it's usually because they know their witnesses stink and they're just not going to be credible later, so they want to get them locked into something right now. Anyway, I hope that helps.